Mr. Hilligus was there. Then he still has some explaining to do why he would vary from the location that pretrial services gave him authority to visit, and then how we make sure that doesn't happen again. So, Mr. Handte, you prepared to answer questions of the court at this time?
Absolutely.
Good afternoon, everyone. Please be seated. Okay, we are on the record in case number CR 19-1535, State of Nevada versus Stewart Handte. Starting with the prosecutor, would you please place your appearance on the record, then defense counsel, and then the defendant.
Yes, thank you. Amos, Stege, Your Honor, here from the State of Nevada.
Mr. Stege, welcome. Defense counsel.
Your Honor, Tom Pitaro, as well as my partner Ozzie, Fumo, and Stewart Handte is present between us.
Thank you. Good afternoon to all of you. Mr. Fumo, welcome. I haven't seen you in Department 8 before, but I'm aware of your existence and glad to have you here today.
Pleasure, thank you very much.
All right. First, a housekeeping matter. When the court, in the related matter of Mr. Hilligus, previously issued a warrant for his arrest, I neglected to order a notice of intent to forfeit his bail of $7,500 cash. I do so now. And so notice entered, an order will issue. I can't remember the statute. I think it has 180 days before the bail is forfeited, but the clock starts to tick from the date the court enters the order, which I plan to enter later today. All right, that's Mr. Hilligus. Number one. Number two, the court became aware this morning of a pretrial violation notice that that Mr. Meredith filed on behalf of pretrial services. The allegation in that notice was that while Mr. Handte asked for permission to leave the county to go to a locker or shed or storage unit in Dayton, Nevada, that he went there but made two other stops that were not authorized, one on and another, the latter of which allegedly is a known address of Mr. Hilligus. And as we all will recall from the court's recent order, Mr. Handte is to have no contact with Mr. Hilligus while Mr. Hilligus is on pending warrant status. So the first question for the defense is, did Mr. Handte go somewhere he wasn't supposed to, and did he have any contact with Mr. Hilligus in violation of the court's order? Because I have concern that the prior order of the court may have been violated. And I'm hoping the answer is no, and there's a reasonable explanation, and we can move past that and get on to the business at hand. Mr. Pitaro, your thoughts on that, please.
My understanding is concerning that issue is that one, Mr. Hilligus was not there, and actually what Mr. Handte went to get were the ashes of his parents. And
That happened to be Mr. Hilligus's home or otherwise a property that Mr. Hilligus owns or controls. Mr. Pitaro?
I have no idea.
Well, I'm going to ask your client, I'm going to place him under oath and ask him these questions, because if it's as you say, then it might be innocuous and it's a big so what. On the other hand, if Mr. Hilligus was there, then he still has some explaining to do why he would vary from the location that pretrial services gave him authority to visit, and then how we make sure that doesn't happen again. So, Mr. Handte, you prepared to answer questions of the court at this time?
Absolutely.
All right, would you please stand up, raise your right hand, and take the oath of witness? Ms. DeGainer.
Do you solemnly swear or affirm the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you. You may have a seat. All right, so Mr. Handte, did you go to, if so, why? And then thereafter, did you go to, and if so, why?
I went down, I initially got permission to go to Lyon County to go to my storage unit, which there's two storage units, one in Lockwood, one in Lyon County. The Cardelli Road address, I had some property I thought was over there, but it's not there. So there was a brief stop.
All right, hold on. Run that by me again. You thought you had property?
Property, yeah. It was property that when Mr. Hilligus cleaned my room out, took it to his house, my storage unit, and there was some tools that he gave to the gentleman that lives at Cardelli Road. His name's Danny Ball.
Of yours?
Yes, of mine.
You thought that those might still be there?
Yes, and they weren't.
Okay.
I went to Wells Fargo because I knew my parents' remains were there. They weren't in my storage unit because I told Mr. Hilligus not to have them there. I did not see Mr. Hilligus, I did not ask. I asked for a gentleman by the name of Kylie, who is the property manager, and I asked to get my parents' remains, since I've now got a room back at my old place of residence, and I didn't feel comfortable of leaving my parents' remains in a storage unit. It was Memorial Day weekend. It's an eighth of a mile, if not less, from each other. The 90 Wells Fargo and the storage.
All right, did you get your parents'
I
remains?
did, and they're with me now.
All right, you understand why that leads to a little bit of a warning signal for those that are supervising you, that if you go to places that you weren't specifically given authority to go to, and in particular a place that Mr. Hilligus owned or controlled, you understand that that's concerning to the court?
I understand, and if I had seen Mr. Hilligus, I would have said, I would have contacted authorities, and you have to turn yourself in, but he wasn't there.
Okay, in the future, if you get permission from Pretrial Services to go somewhere, just go where they give you permission to, and if you're en route or you want to go somewhere else, reach out to them and make sure that they know where you're planning to go so they can keep track of you. You understand that?
I understand.
All right. Mr. Stege, before we move off that to the other business at hand, any questions or comments you'd like to place on the record?
No, thank you.
All right, then the court deems that to be brought to the court's attention and resolved without incident. All right, thank you. Let's move on. So let's talk about the hearing that's been set for today. First of all, we do not yet have a trial date. Previously, the defense indicated it was not prepared to seek to sever Mr. Handte's charges from those currently being asserted against Mr. Hilligus. So whatever comes of the Faretta hearing shortly, we still don't have a trial date. And I guess the question for all involved here is that the order that we intend to maintain pending the warrant being served and the evaluations conducted, and a hearing on the results of those? Let me start with you, Mr. Stege. Is it still the state's position to sort of wait things out, or do you have a different approach that you're able to share with the court at this time?
Depending how the Faretta aspect of this case goes, I see it in the best interest of justice to set a trial date. I understand and appreciate the previously asserted position of the defense on not wanting to have a separate trial. The issue being it is unknown how long we would have to wait for that to occur for a joint trial to be able to be had. A reasonable amount of time has passed since the issuance of the warrant until now, with active efforts made at finding Mr. Hilligus and bringing him into custody. So I foresee in either, however the Faretta pans out, that we set a trial date some months down the road.
Well, please educate the court as to your view. If we do that, and Mr. Hilligus has still not been apprehended, or even if apprehended, his status is not yet clear, does the state have a right to proceed to trial against Mr. Handte only over his objection?
I don't know the answer to that, because it is most typically the opposite situation where one defendant seeks to be severed from the other. And I think, as a matter of trial strategy and judicial economy, joint trials are highly preferable. But I don't want to leave this issue of Hilligus not being arrested to derail for too long of a time the trial as to Mr. Handte.
Well, that's okay, fair enough. And let me just observe this. Let's reverse engineer it. If Mr. Hilligus was apprehended today, the soonest we would have clarity, and that's without a writ to appellate tribunal based on the result of any potential hearing on competency. I mean, we may not have finality for months, many seasons on Mr. Hilligus's status, even if he were to be apprehended if today.
Right, so I will sort of speak with optimism that, I would sort of build in time, if we today decide let's pick a trial date, I would build in some optimistic time that we locate Hilligus, resolve in ordinary or short-ish order the competency issue.
2 evaluations that have to be scheduled, the reports prepared, received, reviewed, analyzed. Then if they lead to one particular conclusion, then a hearing where you can challenge their opinions. If they're, if there's a challengeable issue, if they come up with inconsistent opinions, the court often appoints a third. I mean, we are just, so I appreciate your optimism, but the reality is that it's going to be a while, right? It's going to be a while, even assuming the writ is served shortly. Excuse me, the warrant is served shortly.
I agree.
All right. So Mr. Pitaro or Mr. Fumo, if you're going to have them address the court, what's your thought just on that issue? What if the state asks for a trial date, wants to pursue the trial in the absence of Mr. Hilligus over the objection of Mr. Handte? Does it have a legal right to do so?
Well, let me just start at if I could just go back.
And the reason I bring this up now, aside from logistics and trying to understand court's calendar, is if your client is pursuing to represent himself, he needs to understand what the likelihood is that this case would be set for trial with he as the sole defendant only, even over the defense objection. So I want to know your position on that now, please, if you have one.
Well, let me just start at the beginning. Is concerning the setting of the trial date. The state advised me that they wanted to do Mr. Handte and Mr. Hilligus together. As the court may remember, I stood up in court 2 or 3 times before and said that I was willing to go to trial without Hilligus or with Hilligus at the pleasure of the court.
Well, let me stop you there.
But
You said one time, as I remember, you said we would be prepared to go, or we may even seek to sever. But then later,
Yes.
the last minutes reflect that your client, and then
Yes.
you advised that he was not prepared to. So
Yes.
it's sort of a fluid situation, right?
And so at that time, I then advised the court that our position was no longer to go alone, that Mr. Handte wanted to go with Mr. Hilligus, which was my understanding was the position of the state.
But
Okay.
it might be changing.
It may, of course, and I think it may have today, but up until this, that was always my understanding, the state wanted to do it. And when Mr. Stege and I were talking at that time about trial dates, we were putting it out, what was it, October, November, I think it was, in that area, which is, a ways out, and maybe it can be. So that's that point. As far as can Mr. Handte demand that he wants to go with Hilligus, he has made that demand. I don't have case law with me one way or the other, whether that would or wouldn't be binding. I would assume, though, that even with the absence of case law, it would be a decision of the court to do that, especially under the unique circumstances where this case has been going, and that you have the incompetency issue that is out there, and I agree with the court. That's not something that just gets resolved in a day or a week. It can be a convoluted process to do it. And with that, I just as I'm standing here, although I'm not representing Mr. Hilligus, and that sort of a competency hearing, is it not then wise to appoint, for the limited purpose of that sort of hearing, or that sort of an issue, an attorney independent of Mr. Hilligus, because now you've got I think you have some interesting issues that come up on
The order that I entered with the warrant, I believe, indicated that once apprehended, the court would consider appointing counsel for the purpose of the competency evaluation and its sequela. So you and I are like-minded, because that's not something you usually go along. Okay, so I guess the long and short of it is that the state reserves its right to ask the court to move forward with a trial against Mr. Handte only. The law, none of us it sounds like, often face this type of an issue, so we don't have it at the tip of our mind right now what the jurisprudence suggests, that the court has discretion to manage its docket, of course, that the state decides how to allocate its resources, if it wants to pursue a trial against one of two co-defendants when the other's on either warrant status or an uncertain resolution of a competency hearing. I suppose they have the authority to do that. Does the defense have legal standing and persuasive authority to interpose an objection, which may carry the day? Don't know. Hard to imagine that would be the law, but it could be. So it's really still an open question, but if I had to decide today, I'd say the law probably allows the state to decide consistent with the court's calendar. All right. Let's move on then to Faretta. So we're all aware that under Faretta versus California, the United States Supreme Court in 1975 said that an accused has the legal right to represent themselves. Once the court makes certain findings after a canvass, like the one that the court undertook with Mr. Hilligus several months ago. So before we move to that process, I guess the question for the defense is, and Mr. Handte, is that still what you want? You've got two very reputable, highly regarded criminal justice defense attorneys here by your side, flanking you. If you want the court to go forward though with this hearing, if you've made your mind up that you really want to represent yourself, then I will move forward with that hearing. And I may grant your request, but I may not. I may not. It's not a given. The court has to make certain findings. But sometimes, as you have before, brought this issue to the court's attention and then change their mind or withdraw it or table it. We never got to an actual Faretta hearing the last time. You indicated you wanted the court to consider that, but we never quite got there because other things intervened. But maybe you're at that point now. But are you sure you want this? And if so, do you want a few more minutes to meet with these fellows outside the presence of the court or the prosecutor, for example, in the jury room by yourselves or somewhere else where you could talk to them more fully? Or have you made your mind up that you want to proceed with the hearing and seek to represent yourself?
I seek to represent myself.
Okay. Mr. Pitaro and Mr. Fumo, is that your understanding as well?
That's what he told me before we came into court, Your Honor.
All right. Then under the Faretta versus California case, I'm going to ask you several questions. We administered an oath to you a little while ago with respect to the pretrial violation. The oath remains in effect for purposes of answering the court's questions pursuant to Faretta. Do you understand that, sir?
Understood.
All right. So,
Your Honor, if I could, on behalf of Mr. Handte, I believe that because this is dealing with discharging counsel as well as Faretta, I mean, there's dual issues there that they should be conducted without the state being present, that there should be an ex parte between the court and Mr. Handte.
well, usually with Faretta, it's open to the public, including the state. The state was present during Mr. Hilligus' canvass. But you actually raised an interesting point that I wanted to mention, and that's this. If I deny your request to represent yourself, then Mr. Pitaro and Mr. Fumo are still your attorneys. Now, whether you then seek to discharge them, that's another issue after the Faretta hearing, if I deny your request. Because if you certainly don't have to keep them as your attorneys, but you would have to hire new counsel if you can afford it, or make a proper showing of indigency, and then the court appoints someone for you. So I want you to be clear. That's why I'm not acting on their motion to withdraw or have you discharge them now until we finish the Faretta canvass, because if I decide that you are not going to be representing yourself, then you still have the ability to relieve these fellows as your counsel, but you would be then duty-bound to hire or have appointed somebody else. Do you understand that, Mr. Handte? All right, Mr. Pitaro, does that make sense to you?
Your Honor, here's what I explained to Mr. Handte before we came into court. There's a number of options open to the court, One is to grant the Faretta representation, and he represents himself. Two is that if the court could, if it requests, if he's indigent, which I believe he falls within that, could get appointed a public defender. Or he could go out and hire another attorney through a substitution or whatever, and bring in another attorney. Or four, you have the issue where Mr. Handte can represent himself, but the court then has standby counsel. But I explained to Mr. Handte that standby counsel doesn't write motions, and doesn't participate in questioning. All they do is answer legal issues or procedural questions. So that's what I explained to that before we came into
Okay.
the court. I think he understood that.
Understood.
Well, and the way some other judges have said it to me in the past is standby counsel is a little bit like a well-informed security guard. They observe, they report, they log in, but they don't necessarily engage. They don't argue the motions, they don't cross-examine witnesses. They're there a little bit as a resource, but to step in if and when the court deems it appropriate or the accused determines they no longer want to represent themselves. So they need to stay on top of it, but they don't engage until and unless it comes to pass. So, but you've explained this to Mr. Handte, it sounds like.
Yeah, sure.
All right, but again, I'm not relieving you as counsel until this Faretta canvass is over. Because if the canvass results in the court coming to the conclusion that Mr. Handte does not understand sufficiently the risks attendant, doesn't have the ability to make this decision for himself, and is not fully informed, then you remain his counsel until and unless he decides to make a change or I grant your motion. So I wasn't sure if your motion was, we want out under all circumstances, or we went out because our client wants to represent himself. But we don't have to have argument on that just yet because the court's going to proceed under Faretta versus California. All right, give me just a minute. So Mr. Handte, you can remain seated, but you know some of these questions are not designed to embarrass you, not designed to make you uncomfortable. But I have to get a sense of things to make sure that your decision is rational, that you've considered that you're competent to make this decision. You're making this decision, decisions represent yourself voluntarily, knowingly, intelligently. So let's start from the beginning. How old are you?
62.
How far did you go in school?
Bachelor's degree, University of Reno.
Are you currently taking any medicine for any illness or sickness? Are you sick or injured right now?
No.
Are you lightheaded in any way?
No.
Are you prepared to go forward?
Yes.
Have you had any alcohol this morning?
No.
Have you taken any substances prescribed by a medical professional other than those that you've identified just now?
No.
Do you understand that if I allow you to represent yourself and during the course of the proceedings you engage in disruptive behavior or you engage in any deliberate activities to frustrate the ends of justice, that I can rescind the court's decision to allow you to represent yourself, at which time you would either be required to hire counsel if you could afford it, or have the court appoint counsel for you if you were deemed indigent. Do you understand that?
Understood.
Excuse me. Are you currently under the care of any mental health provider?
No.
Has anyone threatened or coerced you in any way to represent yourself?
No.
Again, with respect to making a change of attorneys, if you could not afford to hire private counsel on your own and you were deemed indigent, the court would appoint counsel for you at no expense. Do you understand that?
Understood.
Do you understand, Mr. Handte, that if you represent yourself, you will be responsible to follow the rules of practice that govern criminal justice proceedings here in Nevada 2nd Judicial District?
Yes, very familiar with it.
You understand that there are both procedural rules and substantive rules that govern a criminal justice prosecution that you will be responsible to follow, just as the prosecution will.
Understood.
Do you understand that if there is a conviction on some or all of the charges against you, and you deem an appeal warranted, you will not be allowed to complain on appeal with respect to the competency or effectiveness of your trial representation because you are representing yourself?
Understood.
Do you understand that the state is represented by an experienced prosecutor who may take advantage of the training, experience, education that he has that you do not?
Somewhat understand. I do have 30 years of law enforcement experience.
I am aware. But still, in terms of courtroom experience, talking to juries for purposes of the art of persuasion, making arguments to the court, filing motions, pleadings, reviewing and commenting on jury instructions, evidentiary rulings, things like that, you're going up against a very seasoned and experienced prosecutor. Do you understand that?
Understand.
Do you understand that as a self-represented accused, you'll have access to a law library as would any other lay person? In other words, you don't get special privileges. We don't extend the hours available. We don't give you any special privileges that somebody who's not an accused in a criminal justice matter would otherwise have.
Do I still need permission to come down there?
Well, if you're going to be representing yourself, you can have access to the law library. We'll make sure that's not deemed a pretrial violation.
Okay, thank you.
Do you understand that?
I do.
Now, how many different counts have been alleged by the state against you in the criminal information that was filed in this case?
Initially 2, then the 1. I believe we're sitting at 3 right now.
3 counts. Do you know what the counts are?
Kidnapping, conspiracy kidnapping of a protected person and burglary.
Correct. With respect to the, I'll call it count 1, conspiracy to commit second-degree kidnapping, do you know what the possible sentencing range is in the event of a conviction?
I researched it, yes.
All right, and so how many years in prison would you be looking at it for the maximum under Nevada law if you were found guilty of that charge?
I believe it's 6, but maybe off.
It is 6, thank you. With respect to count 2, the burglary, same question. Do you know what the sentencing maximum is for that count?
1 to 6?
It's actually 1 to 10. So it could be up to 10 years in prison. Do you understand that?
Correct.
All right, and then count 3, second-degree kidnapping of an older person. Do you know what the sentencing range is on that? And then do you know if there's an enhancement on that because of the age of the person involved?
I believe there's an enhancement, and also I believe it's at least 10 to 20 years.
So let me double check with Mr. Stege. I believe the sentencing range is 1 to 20, and then an enhancement possibility of 2 to 15. Does that sound right to you?
2 to 15 plus 1 to 15.
2 to 15 plus 1 to 15. Got it, thank you. And that by law would run consecutive in the event of a conviction of count 3?
You're correct.
All right, so making sure you understand this, Mr. Handte, in the event you were convicted of all 3 counts, and in the event that the court thought it fair and just to sentence you to the maximum, and in the event that the court felt it fair and just to run all the sentences consecutive to one another, which means one after the other, you would be looking at 6 years plus 10 years plus 15 years plus 15 years. 46 years in prison and eligible for parole, not more than 40% of that time. Do you understand that?
I do.
Do you understand that aside from the current plea that's been entered in this case of not guilty, you would have the right to seek to plead no contest, which essentially would mean, if you changed your plea, that while not admitting any violation of law, that you would recognize that the state had sufficient evidence to prove beyond a reasonable doubt the elements of one or more of these counts. Do you understand that?
I do, and I do not wish to change my plea.
You understand, as I talked about with Mr. Pitaro, the court has the right to appoint, even over your objection, standby counsel, which would be an attorney who would be with you at trial and be available in the event the court determined that you were no longer able to represent yourself. Do you understand that?
I do.
Do you understand that as an accused, you have a right to remain silent at trial? You do not have to take the stand and testify. Under the Fifth Amendment, you could remain silent, and your silence would not be used against you. In fact, the jury would be instructed that they were to make nothing of the fact that you chose not to take the stand in your own defense. Do you understand that?
I do.
Do you understand that as well you have a right to take the stand and testify?
I do.
Now, when a self-represented person takes the stand and testifies, we have to develop a protocol, an approach for how that person testifies. It can be one of several different ways. For example, a narrative, under oath narrative. It can be, for example, certain questions that you've indicated you would like to be asked, that the court looks at in advance, the state looks at in advance, and decides whether those are questions that should be asked of you. And then the court can direct who would ask those questions. We also have the ability to well, those are the two ones that I've seen before. So those are the main ones. So if you represent yourself, and if you make a decision to testify, then we take a break before that would occur. I make sure that you understand what you're doing by taking the witness stand, and then we discuss how this is going to go. Do you understand that?
I do.
Now, one more thing, or a few more things. One is, the court recognizes that you're out of custody on bail, pretrial supervision. Other than the issue we talked about this morning, I'm not aware if there's any other concern with the way you've been conducting yourself. That's all good. But in the unlikely event that an issue arose, resulting in the court revoking your out of custody status, you would still be representing yourself while you would be in custody. Of course, at that time, the court would have you back in and consider whether you would continue to represent yourself or the court appoint an attorney for you. But until and unless that event occurred, you would be your own attorney. Do you understand that?
I do.
Did you understand the discussion I had with Mr. Pitaro and Mr. Stege a short while ago to the effect that this case may proceed to trial without Mr. Hilligus present as a co-defendant?
I understood the dialogue, correct.
Okay. And the court hasn't made any decisions. It's not currently yet an issue with the court, but I may set a trial. I may direct you and Mr. Stege to contact the jury commissioner and set a trial date, as well as a pretrial conference date, as well as what we call a motion to confirm date. That's without prejudicing your right to ask the court not to go forward with trial if Mr. Hilligus was not part of it. But I've already telegraphed to you, as I did to everyone here, that although I'm not sure what the law is on this, because it's not an issue that comes up very much, I'm somewhat convinced that the court has discretion to allow the state to go forward as against one of two defendants if the other defendant is unavailable. You understand
I understand. I got the research.
Do you understand that in the event of a conviction and you decide to seek an appeal of any or all of the counts, that you have 30 days from the date judgment is entered to file a notice of appeal?
I do now.
And knowing everything that you know as you sit here, and having had the benefit of Mr. Pitaro and apparently Mr. Fumo as well, going through different court appearances, your familiarity with the criminal justice system based on your professional experience, is it your firm desire to represent yourself in this matter?
It is.
Fair enough. Court finds that Mr. Handte is competent to waive the right to counsel, and he has done so. Court finds that Mr. Handte is freely and voluntarily and knowingly waiving his right to counsel. Court further finds that Mr. Handte has a full appreciation and understanding of the waiver of his right to counsel and its consequences. Based on that, Mr. Pitaro, Mr. Fumo, your motion to withdraw as counsel is granted. You are relieved from your further responsibility to represent Mr. Handte in this matter. If you just sit tight for 1 or 2 minutes, and then when we end this hearing shortly, off you go.
Just for clarification of the record, we filed that motion at the request of Mr. Handte.
Understood. All right.
And we also gave him a copy of his full discovery on the thumb drive this afternoon.
Okay, very good, thank you. Mr. Handte, is that correct? You received your essentially the important portions of your file from your counsel?
This is the second time I've received it. I actually got one from Mr. Pitaro a couple weeks ago.
Okay.
So I got two.
You know, these are two professionals, even though they're not going to be your attorneys any longer. If you call and say, hey, I can't open this file, I don't understand what this, the way you've indexed it or organized it, I'm going to assume that they'll be available to answer those type of questions. If you ask them legal questions, they won't be answering those because they're not your lawyers anymore and they don't have professional duties or fiduciary duties to you. But they, I'm sure logistics and organizational, administrative, they'll be available. Do you understand that, sir?
Yeah, I believe they will be available. There's
Okay.
no animosity there.
Okay, Ms. Pitaro, that's your understanding as well?
Yes, Your Honor.
Of course. All right. So what happens next is this. I'm ordering counsel and Mr. Handte to, within the next 48 hours, contact jointly the jury commissioner, Ms. Kylie Lane, and set this matter for trial. Mr. Stege, assuming it's a one defendant trial, how many days does the state anticipate for a trial, please?
I would ask for 7 trial days.
Okay, so because of COVID and because of occasionally we have jurors who get ill during trial and we have people show up for service who we have to let go because of medically related issues, we get probably 60 or 65 jurors in a 7-day trial. And so when would you roughly be looking from the state's perspective?
I think that the previously mentioned time, the sort of the end of the year, October, November strikes me as a sweet spot, for the case.
So middle to late fall?
Yes. I'm open-minded with the court schedule as well as Mr. Hante's, schedule.
Well, I don't have any no set areas around that time. There are other matters that are already set there, but we'll do our best to have this court try this case or another judge. I mean, that's how it goes. Either one of my colleagues, if I'm in trial on another case that has a higher priority than this, or a senior judge, which Judge Palaha was called in to try a case recently here. So you might not have Department 8 presiding over this case, but the goal would be for me to try it.
And for the foreseeable future, we will have trial flights. Is that accurate?
I believe at least through the end of this year.
Thank you.
Mr. Handte, from this point forward, when you address the court, if you would please stand up. So within 48 hours, connect with Mr. Stege, contact Kylie Lane, and there are 3 dates that we're looking for now. One is the trial date, and again, the way it works is we don't necessarily say these 7 days are your trial dates. We put you on a trial flight, which means for 3 or 4 weeks, you could go anytime during that 3 or 4 week period. So whatever flight you're put on, you need to make sure you're available that whole 4 weeks. When we get closer, we narrow down what actual days will be your trial. But if you get on a trial flight that begins, for example, October 15th, and it's a 4-week trial flight, you need to keep October 15th through roughly November 14th available. That's the first date you're gonna get, is your trial flight. The second date is about 2 or 3 weeks before, there's another court appearance, not with me, but with a different judge, to confirm the trial. That there's nothing that is causing it not to be ready to go. The phrase we use for that is a motion to confirm hearing. So when you set the trial flight, also set the exact date and time for the motion to confirm. And then third, once you have your motion to confirm, then please jointly contact my judicial assistant, Jamie Barrett, and set a final pretrial conference in person. And at that time, we will go over any pending matters, motions, logistics, let you walk around the courtroom a little more, sit up there, sit over and see where the jury sits, sit back, wherever you want. If you have a computer or a laptop and you want to hook it up to our screens, so to show the jury something that the court allows, we can practice with IT. That's what we do at the pretrial conference. So 3 dates, trial flight, motion to confirm, and then once you have those 2 dates, then contact Ms. Barrett for your final pretrial conference. I think, are there any motions that previously been filed and submitted, Mr. Stege?
I think all motions have been decided with respect to Mr. Handte.
Okay,
And I will, I see in the motion filed by Mr. Pitaro, a certificate of service by e-filing that has the defendant's email address. That is what I will use.
okay.
Contact.
Do you have to open up an e-flex account?
Your Honor, I've already tried to, it's in pending status.
It's currently in pending status? All right, well, if there's anything we need to do to push it over the line, let us know. I'm assuming now it's not, oh, let me back up. I think it's pending status because you were represented by counsel, but now that you're representing yourself, it seems to me that it should go from pending status to active.
Agreed.
All right, so that's how you file things, you serve them, Mr. State, you get served when you file something, you get served when he files something, and you'll see when the court issues an order.
However, on that point, Your Honor, as we mentioned last time, with Hilligus's items, they weren't coming to the Handte side, and I think the court at that time asked the clerk to make sure that there was a cross of motions or orders, et cetera, between the two.
So I'm not sure, yes, you're right. So what happens is you file something in this case, and Mr. Hilligus's case doesn't necessarily get it, and people involved in that might not see it. I'm not sure, maybe Ms. DeGainer knows the answer to that, or, but if something's filed in this case, a courtesy copy of it at least should be filed in Mr. Hilligis's case,
and vice versa.
and vice versa, yeah. So any thoughts on that you can share at this time?
No, Your Honor, I'm not sure that he could.
Could file it that way?
Yeah, I'm not sure.
All right, well, if you file something in this case, for now, we'll make sure it gets a copy filed over in Mr. Hilligis's case as a courtesy copy.
I do have a document, but I will go through the e-flex process and get it confirmed first.
Okay. Anything else, Mr. Stege, at this time?
Thank you, no.
Anything else, Mr. Handte?
Your Honor, I do have one matter.
Go ahead.
Okay.
Mr. Handte, you may have a seat.
Normally in Las Vegas, when a person is allowed to represent themselves, the court appoints standby counsel. And I am not sure if the court, one, is going to appoint standby counsel, and two, if the court is going to appoint the law.
Well, I'm not doing it at this, at your firm or somebody else?
No, that's on that, our firm as standby counsel or not. I mean, I just want to know that before I leave. If you are, that's the court's order. If you're not, then that's the court order. All I'm saying is that, at least my experience in the Las Vegas courts is when a person represents himself, the court normally appoints a standby counsel. And I don't know what the procedure is up here, but I'm making the court
It's case by
aware of that.
case, right? Case by case basis.
Just so I know what I am and am not doing.
Well, Mr. Stege, do you have any strong thoughts on that?
Only that I think we were both reading the rule together as you had during the canvass, at least myself and defense counsel. I think that's an option, it's not strictly required. I think the constitutional principle at play is it's the defendant's right to represent himself, and if he passes the bar, if you will, to that process, he may do so. Given, I think, the first inquiry would be, does Mr. Handte want standby counsel? But two, I think, given the uniqueness of Mr. Hante's life experience, that would sort of lean the state against against that process. I've never heard of sort of a everyone gets standby counsel who represents themselves.
Well, not in the second judicial. Other counties may be different, right?
Right, well, and at least in the time I was in the 8th, that was not a standing issue, so.
Okay. The answer is I'm not doing it at this time, but certainly I reserve the right to appoint standby counsel. And, I mean, you would be at the top of the list, but I don't want to have you do anything differently than you otherwise would as somebody who has now been relieved as counsel. All right, before everyone goes, one last thing. Nevada Supreme Court Rule 252 allows the court to suggest, cannot order, but suggest, that parties to a criminal justice matter go in front of a different judge for a dispute resolution conference, mediation, settlement conference, work it out. Now, I can't force it, but I certainly, in a case like this, would encourage it. You don't have to make any decisions about that as you see there right now, Mr. Handte, and certainly whatever your decision is, I don't direct you to somebody until both sides agree. So the state might say, great idea, Judge, we're willing to go in good faith. And you might say, no, thank you. Or you might say, Judge, I'll go and listen to whatever that other judge has to say, and listen to what the state has to say, try to work this out. And the state might say, Judge, we're not interested. We're going to trial. But I want to at least offer that. So what I would suggest, Mr. Handte, is think about this. And the way it works is if you both say yes, I direct you to a different district court judge, one of the other 8. Or if you agree, I believe a senior judge. And you set up a time to go see him or her. You each probably deliver to that judge your private view of things. Only the judge sees it, not the other side. I don't see it. And you go there and you work and you try to settle this. If you go and you do not settle, I don't hear about it. I don't talk to the judge. I don't talk to the judge before. I don't talk to the judge after. All I would learn is parties went to a 252 settlement conference and did not work this out. I don't have to know why. I don't have to know which side, if either was the reason it didn't work itself out. I just know they tried and on we go. On the other hand, if you go and you work it out, then later I learned, judge, the parties have worked it out. And then there are further proceedings here consistent with however you worked it out. If this were a civil case, it's not, but if it were a case about money or property or people's rights, I could order you to go. You have to go. You wouldn't have to settle, but you'd have to go. Criminal justice matters, I can't order it. I can just suggest it. I do so now. This case has been pending a long time. It's taken its toll on people, personally, professionally. State has a strong view of what happened here. I know you do as well, Mr. Handte. My job is to make sure that you get a fair trial. Make sure both sides get a fair trial, I should say. But I encourage you to give some thought to what I said. Mr. Stege, I encourage you to give some thought. And by the time you two talk and connect with the jury commissioner, Ms. Lane, please, if you're in a position to do so, let the other side know if you'd be interested in a Rule 252 settlement conference. If so, you just let me know that and I'll set it up. Again, I don't talk to the judge about what the case is. All I do is arrange someone and they reach out and schedule it. Any questions, Mr. Handte, about what I just said?
No.
And Mr. Stege, any questions?
No.
All right, thank you very much, everyone. With that, the court's in recess.
All rise.